Good evening. Hi, Judy. This is the Walpole Zoning Board of Appeals. Tonight is Monday, December 16th. It's 7:15, and we just came out of executive session. In the first case, we have, we're going to do something under board business. We're going to have a discussion and then a vote, and this is on the Dupee Street Diamond Hill Estate units to 12, and seek a waiver to reduce the rear yard setback from 30 feet to 20 feet. So we have with us town council, and I see that the applicant is with us also. So on this, we have the set of plans, and all we're doing tonight is we're going to have usually it's a brief discussion to decide whether this is a substantial or a non-substantial, town council?
Insubstantial.
Insubstantial, okay. Insubstantial change to the project. So, that being said, we can start with the discussion of what's being proposed. And let me ask, is there anybody here from, for this, from the neighborhood on Dupee Street? Okay. So, Mr. Petrosi, do you want to walk us through what's being proposed with your change?
Thank you, Mr. Chairman. For the record, Lou Petrosi for Wall Street Development Corp. As you've correctly stated, this is a project that was approved last year with a comprehensive permit. Recently, a homeowner has approached Wall Street to purchase their property. What you see highlighted in or outlined in red is the existing property at 3 Dupee Street. Consists of a single-family home with a 2-car detached garage, approximately 20,000 square feet. We're proposing to, what I have here is the existing development. We have 3 detached single-family homes on sheet 1 with a proposed stormwater basin highlighted here in green. With the addition of the property at 3 Dupee Street, what ends up happening is that we're able to remove the 2 buildings that are existing there today and add 4 additional single-family homes of similar size and shape, and simply requires the repositioning of the detention basin a little bit further north on the site. One thing about this particular change is that the infrastructure on the property is, for the project is not changing. We're building this road, and all of the infrastructure, regardless of whether or not this property is acquired, it has virtually no impact on any other parts of the site. The detention basin would have to be designed and reviewed. And other than that, the project remains the same. It's really a net increase in 3 units because there's 1 unit that the existing single-family home is being removed. So it's a net increase of 1 unit, of 3 units, and essentially an increase of only 2 buildings versus, because 2 are there right now and being removed. So other than that, it's pretty much, from my position, would consider it a minor change.
Okay. So, from my position, we spent a lot of time on this. A lot of discussion was done on the drainage basin, so I think this is a substantial change, in my opinion, but we can see what other board members think about that.
Mr. Chairman, so I think one of the major concerns I had with the project was the turning radius of the fire truck, and adding additional housing units to that roadway certainly poses a safety concern of mine, so I'd also agree it's a major modification. I'd like to feel more comfortable with a turning radius analysis along with a traffic study, and then whatever calculations are needed with the drainage basin also.
Mark?
Yeah, I feel like if the drainage basin wasn't moving, I'd be more comfortable. But with that moving, I kind of want to make sure sewer and water have had a chance to look at this a little more closely, provide some feedback. And then I mean, understand this, most of the other stuff that was approved is not moving. It's just the drainage basin, I think, that kind of tips it for me as not being minor.
And also, neighbors on Victoria Circle, they thought they had a defined plan. Now it's a modified plan, and they should have some chance to be involved with this. So, Tim, anything else from you?
But you just said in reducing that line from 30 feet to 20 feet just seems to be making it more dense than it was the first time, which I think we thought it was pretty intense to begin with, but I'd say a major change.
Okay. Okay. Nobody here from, is there anybody here from the public to comment on this case? Okay. So at this time, Town Council, should we make a, how do we do this? We make a motion to determine that it is a substantial change?
That's exactly right. That's what the regulations call for, that you have to act on the request within 20 days of receipt to make a determination either if it's substantial or insubstantial. If you found it insubstantial, the permit would be deemed so modified. If you determine it to be substantial, you'll proceed with you'll notify the applicant of that. I know he's here tonight, but you would formally notify him of the vote. And then you would have to commence a public hearing on it, just like a regular 40B application.
Okay.
The applicant has the right to appeal that, or he can defer the appeal, proceed with the hearing, and reserve his right later to appeal, depending on what happens with it.
Mr. Chairman, may I ask a question of Town Council?
Through me, yeah, sure.
Through you. I'm not quite sure, when is the board, what triggers the public hearing? Is it an application by me, or is it the board set that on its own, based on the decision that they make tonight?
Yeah, so
it's-
I would work with Patrick to get a date.
Okay.
If it can't be done within the 30 days, I'd get an agreement. My position, it's not spelled out in the regulations, my position, though, is when you deem it substantial and it requires a public hearing, you get the full 6 months from the date of commencement of the hearing. It doesn't open up all the issues. You are limited to issues presented by the change. But in my opinion, you have the full 6 months to then render a decision as though it was the original permit.
Well, that's where we probably would disagree, but we'll work it out.
Okay, so does somebody want to make a motion that the zoning board has determined that this change is a substantial change to the development?
So moved.
Second.
Okay, moved by Drew, second by Mark. Any further discussion? Okay, Town Council, we on the right track on this?
Yes.
Okay, okay. All those in favor of determining that this is a substantial change to the site, please say aye.
Aye.
Opposed, abstained, okay, so carried.
And then
4-0-0.
from here, Mr. Chair, Patrick should formally notify the applicant. And then if there's not an agreement about commencement of the public hearing, I recommend you schedule within 30 days. Even if you're not prepared to go forward on a substantive hearing, get it scheduled within 30 days and see what you have for a quorum that night, so that you don't end up with a constructive approval of it by failing to commence the public hearing within 30 days.
Okay,
Can I ask one more question?
sure.
And if I understand it correctly, it's just the changes that are related to the additional units. It's not, we're not reopening up the whole project evaluation or review. It's related to, as Mr. Delaney has indicated, he wanted turning radiuses and other things that are previously been adjudicated by the Housing Appeals Committee and the board.
Not to butt in for George, but the board has also done with this with 55 Summer Street, and I remember that also kind of being the same topic of what was being reviewed, and the review was based solely on what was being proposed within the change, not a review of the entire project.
Right, but.
Anything
if-
reasonably
that
related to
changes-
the
Yeah.
change.
Right,
Yeah.
so I think Mr. Delaney said traffic, so there's more units, there's going to be more
Right,
traffic,
but-
so.
but turning radius is another thing that's really kind of been already hashed over quite a bit.
Well, we'll have to see if anything's changed, we take your word that the only parts that's changing is down on this end, but we're going to want to make sure that that's what's.
Of course, you
what's
don't trust me.
I do trust you.
understand
Yeah,
completely.
so, okay.
George, just one way here, and for the board's purpose, so I'll put the board's decision in writing, send that to the applicant, and then from there, do I set up
It'd be
time?
preferable to work with the applicant
In
to get
terms
an
of a
agreed
public-
date to commence it, but
And
if
then
you
have that in
don't,
writing?
I would just do it in 30 days.
Okay.
Okay,
Yep.
that it? That's it for me?
No, well,
Thank you.
no. We have other things for you, Mr. Petrosi, this evening, but, okay. The next, so we're clear on that, Town Council, you good?
Yep.
The next case we have is case number 2419. This is 92 County Road, special permit under section 123C5 of the zoning bylaw to allow impervious coverage in excess of 15% within the water protection overlay district, area 4. The applicant is proposing to construct a two-car garage on an existing developed, single-family residential property. So, we were here a couple months ago, and then at the request of the applicant, it was continued last time, and now we are here again. So, Mr. American, good evening.
Good evening. For the record, Dan Merrick, Legacy Engineering, here on behalf of the applicant. When we last met, the abutter presented a stipulation from 1987. We have reviewed that with the applicant and their counsel, and essentially the stipulation restricts certain activities on the easterly portion of the property, the easterly half roughly of the property, but it does not affect work on the westerly portion of the property, and the proposed garage is on the far westerly edge of the property. So there's nothing in that stipulation, in our view, that would preclude the garage. We've provided a plot plan with a stormwater infiltration system per standard practice for the new impervious coverage roof runoff, and this is the typical set of requirements for an impervious coverage special permit in the groundwater protection district.
Okay. So, one of the things I know, when I looked at this old document from back
1987.
1987. Did you look into why it was Joseph P. Germano?
Appealed the issuance of the building permit, right? So when you appeal a building permit, first it goes to the zoning board. I presume the zoning board upheld the issuance of the building permit, and then that went to court on further appeal. So this stipulation was the product of that appeal, of their appeal of the building permit issuance. So that's the history of that document.
And it's a zoning board, this was, Joseph P.
zoning board
Germano
was involved.
on the zoning board at that point.
Because it was the appeal of your prior upholding of the building permit for the house construction. So that, the stipulation occurred before the house was built, and it basically laid out those limitations on the easterly half, but was not, obviously the house got built and the driveway got built, that was always the intention, that the westerly portion could be used for structures and driveways and septic systems and things of that sort.
So, as I looked at this 1987 document, one of the things the neighbor, Mr. Barcelo, had put an arrow to was paragraph 6. And I actually thought the part that is most important for what we're talking about tonight is the next page, which is still paragraph 6, and it has to do with preserving the natural permeable conditions of the easterly portion of the locus as a natural water drainage system, except with the written consent of the plaintiffs or the successors of ownership, provided, however, this shall not, then this was the important part, However, this shall not be construed to prevent the utilization of the easterly portion of the locus for gardening or similar passive recreation activities. So that's what the neighbor was talking about. But if you look over at paragraph 12, this is where I thought it relates to what you're talking about. Have you looked at paragraph 12 on this?
I've read the whole thing, yeah.
Okay. So on paragraph 12, it talks about the Palumbo shall comply with any further governmental regulations of the locus, especially as the same concerns of the westerly portion of the locus. The intent of this stipulation is to prevent undue, unnatural runoff onto the plaintiff's parcel by any construction or activity on the Palumbo parcel. And that brings us to where we are tonight. That's how I see it, so.
Except that the area that we're proposing to work on does not discharge towards the Palumbo property.
Okay, but you're discharging into the ground, right?
Well, we're proposing to put rainwater into the ground, but that talks about stormwater runoff into the Palumbo property. The Palumbo property is to the east. So if you look at the plan,
Oh, yeah.
on the Palumbo property is on the right half of the plan. Our garage that's proposed is on the left half of the plan, on the west side. None of the runoff from the west side of the property goes into the Palumbo property. Goes into the neighbor at 1 Starlight Drive.
So I think one of the things that we're dealing with is a area where water flow is a concern, and this agreement specifically says that, prevent undue natural runoff onto the plaintiff's parcel by any construction or activity. So I think it raises concerns that it's already been said that back in 1987, they were looking at the flow of water, and we're still looking at that issue.
But it says specifically, flow onto the plaintiff's property. The plaintiffs are the Barcelos. The water only goes downhill. If the land is not sloping from the westerly portion of the site to the Barcelo property, it's not discharging runoff. It's not flowing to the plaintiff's property in that stipulation.
Okay. So when the water goes underground, as it's being put here, where does it go from there?
It would flow south towards the wetland further down Starlight Drive. There's the whole wetland system that goes all the way down, crisscrosses through Starlight Drive, goes into Adams Farm.
I think one of the things, once water goes in the ground, the best answer would probably be, we're not exactly sure where it goes once it goes underground.
I'm sure.
Okay. Anybody else have any questions or comments?
I guess, sorry, Chairman, just so I understand it correctly, what is the elevation where the proposed garage is?
So if you look at those, the contours are the dash lines.
Yep.
So water flows perpendicular to the contours, always perpendicular to the contours, because that's straight downhill. So if you look at the elevation of the garage, it's 278 up, and that's the vicinity of the garage elevation.
What's the elevation on the southeast corner of the property?
On the southeast corner of the property is 276, then it goes down to 274. I'm sorry, southeast is 272.
Okay.
Actually, 270 right there.
Right. I mean, that's the southern edge, but the southern corner is 272. But you're saying when it sheds to the southern border? Is that what the...
Yeah, the water from that area sheds into the property of 4th Starlight Drive. It
Okay.
doesn't shed into the Barcelos property.
Thank you.
Yeah, I think my take on this is, I mean, I get that there's a lot of history here with this property and clearly sensitivity, but it sounds like everything is kind of isolated to the eastern part of the property, which could actually improve the amount of runoff going anywhere else from today. So I think, I don't see enough here to say this shouldn't go forward. That's my take.
Judy? Tim?
You want to go?
I agree with you. Once it goes underground, I've seen it in my own experience with construction, houses being built, it can change everything what's going on. So it does look lower in that southeast corner.
Anybody from the public want to comment on this?
It's very hard for us to hear you.
Do you want to, somebody from the public want to comment on it?
I'm sorry. Do you want to have anything to say?
Feel free to step, make any comments.
Into the mic.
I'm hard of hearing. I can't hear you. But I want to go along to say that he can have all the charts of what is supposed to happen and what does happen. I can tell you what did happen. I have lived on this property all my life, 85 years. Never had a problem with water. Then Mr. Palumbo built his house. I had to put in a sump pump. That was fine. I'm not trying to take anything away from him having a house there, but he doesn't stop at that. About 2 years ago, I don't know what he's doing over there, but I have a walkout cellar with there's about 5 cement stairs going up and out. And in the bottom there, I had put in a drain, crushed stone and everything in a little drain there. 2 years ago, the drain was not working. The water was coming up out of the drain. I have to put another sub pump outside the house to take care of this from flooding my cellar. Also, this is not concerned with you in this appeal, but there is an appeal before the Board of Health and the Conservation Commission that the water coming through onto my property is polluted with animal, bird waste, chickens, all kinds of that. That is still going on, but it's all amounts to water coming onto my property. I'm at the bottom of the hill of where his house is and where he wants his new garage to be. So I can't take any more of this. I don't know what the Board of Health will do. We'll find that out, but that has to, they say, oh, that has nothing to do with this, but it does. It's all about the water. And I hope you will vote against him doing anything else. Thank you very much.
Anybody else?
Yes. Good evening. My name is Michael Sams. I'm with the law firm of Kenny and Sams, and I represent the Palumbos, the applicants before you. I just want to speak to a couple things, and I think it's important for you to consider. One is the overall context of what the Palumbos have been dealing with the last 4 decades. The other is why I don't think the agreement that has been referenced, the stipulation and the judgment, are relevant to what's being decided here. There may be other issues for you to consider that are beyond my expertise, but I don't think that the judgment and the stipulation are relevant. As you consider this, I'd like you to put into context what has happened over, again, almost 4 decades. When the Palumbos went to build their home, they were faced with opposition from their neighbor. You heard about the process, got approval here, had to go to court. They eventually entered into this stipulation and judgment just so they could build their house. They then proceeded to try to build their house. And while they were trying to build their house, they heard it was too high. Then they heard the septic tank was too low. Then they heard the fill that had been, or the slope that had been agreed to wasn't exactly right. They dealt with all of that. Then, one day later, not one day later, but one day, Mr. Palumbo parked a compressor in his driveway. He had to come down and deal with the town for that because it had a commercial license plate on it. And then one day they decided, like some people do, we want to put an addition on our house. The neighbors opposed that. They went through 2 years of on and off dealing with the town before they could finally get that built. More recently, well, over that entire time, they've been dealing with this issue that the abutter raises with respect to the chicken coops. And I know that because I've been down before this Board of Health 6 years ago and put that to bed before the Board of Health. We've had to move chicken coops. We had to remove a path that led down to the chicken coops. And we did this all voluntarily, just to try to keep the peace. The reason I'm telling you all of this is every time the Palumbos want to do something on their property, they end up spending hours and hours and countless amounts of dollars trying to address what the neighbor raises. I'd call it the Hatfield and the McCoys, but it's really just the Hatfields again and again and again. I think it's important you understand that context it's been 37 years of harassment that the Palumbos have had to deal with. And they don't push back. They don't push back even though the neighbor's property floods water onto theirs. They just want to deal with their own property. They want to live in peace. And they've bent over backwards to satisfy the town as part of that process. Now, as to this stipulation, I think this board got it right, as I understand it, when the issue first came up. When you look at paragraph 6, it's talking about, I think it's important to see where the agreement talks about intentions. And you'll see it in a couple different spots, but in paragraph 6, it says, "It's the express intention of the parties that fill shall never be introduced to the easterly portion." That's what this agreement in all of the different paragraphs deals with in one form or another. In fact, to the extent that the neighbors are unhappy with the fill on the easterly side, in paragraph 9, they shouldn't be here. They should be hiring a lawyer or handling it themselves, but seeking an injunction in the courts. That's what they should be doing if they're unhappy with the Palumbos' use of the Palumbos' own property. They shouldn't be taking up this board's time with it. They should be going to court. They've got an express right to get an injunction preventing things if they're right. Paragraph 12, and I think it's the sentence of the agreement. The intent of this stipulation is to prevent undue or unnatural runoff onto the plaintiff's parcel by any construction or activity on the Palumbos' land. Now, I think what's important is, in the context of the whole document, it's the whole, and the slope on the easterly side. That's it. That's it. And there's a reason for that. It's because on the easterly side, it's where it could impact the neighbors, not the westerly side. But to the extent there's any issue, it says, because I heard the board talking about underground water. Respectfully, that's not what this agreement is about. It says the intent of this stipulation is to prevent undue or unnatural runoff onto the plaintiff's parcel. That's a specific word, onto, not under. But to the extent there's still an issue that the board has as it interprets this agreement, I would suggest to you that there is no evidence that anybody's come to, nothing anybody's put before you. Indeed, Mr. American spoke otherwise. He's put other evidence in front of you. But there's no evidence that even underground water is going to flow onto the neighbor's property. None. All of the evidence before you is to the contrary. So respectfully, I'd ask you to approve the application. We're only here because of harassment over 37 years and because of an agreement that was raised that has no applicability before, with respect to the issue before you, namely the building of a garage on the westerly part of the property. I'm happy to answer any questions, but otherwise I appreciate you taking the time to listen to me.
Anybody else? Sure.
I'm Ann Barcelo. Wonderful speech. This is a non-conforming lot. In the early 80s, there was a gasoline leak. Everybody lost their wells, not everybody, but Texaco brought water up to 109. Therefore, it was a piece of land that would be very good for a house, which we agreed to. It was just an empty lot. But we are the lowest point on Route 109. Dover takes care of the road. There are no catch basins. So we do get water left and right. When they built Crosswoods Path, that engineer was most understanding that he had to do catch basins, and there's a drainage south of our property on the next. And it, like Bernie explained the last time, he's lived there long enough, he knows the water flow, it goes down through, it goes, we call Bruce's Pond, finally Vine Brook, which is what a water source for Walpole. He also meant, the lawyer also mentioned when they built a addition to the house. We came to the building inspector asking what is he doing over there. He says, well, he has a permit for a 4-bedroom, 4-season. And while Bernie was going over in another room with the building inspector, I said to the assistant inspector, when one board comes to a person's house, in other words, the Board of Health, to check animal conditions and so forth in your permit, and you see something odd, or vice versa, when a building inspector comes to inspect the footings, and he looked at me, and I said, well, he's building a room, so he left, and he came back, and he said, that was written in the application as a previous concrete slab, foundation. It wasn't. It was his deck. He tore down the deck and he poured a foundation, then applied for his application. That's why there was a stop order on the 4-season. And then they had to go through the process and get an appeal, and the room was built. And as far as his comments about his company trucks, Rivoli, there were 2 or 3 trucks, and we took a picture of the trucks, and in the picture showed that it was a deck, not a foundation. And I'm losing my train of thought. He also had put in a second driveway so that those trucks could come to the easterly side of his house. They stopped that. He was ordered to remove the driveway, and the trucks no longer were able to be parked there. So my papers are on my kitchen table, but the lawyer that we had originally, may he rest in peace, he wrote when he sent us all our information, please keep an eye on this individual. He seems to do what he wants to do. That's my explanation of what Mr. Palumbo, it's not all Barcelos feuding with the Palumbos. Thank you.
Okay.
Mr. Chairman, I just note a couple of things. Mr. Barcelo mentioned the engineer who designed Crosswoods Path, understanding the issues on that engineer. I designed Crosswoods Path. So I provided you with a plan with a drainage design to mitigate the roof runoff from the very small two-car garage that's being proposed on the westerly portion. I'm an engineer. I'm offering my opinion that it's not going to have any adverse impact on the Barcelo property with respect to runoff, because the water does not discharge towards their property. We respectfully submit that the application meets the requirements for a special permit under the Water Resource Protection Overlay District, which basically simply requires that you provide some recharge for the additional impervious coverage. That is the purpose of the Water Resource Protection Overlay District, is to ensure the continued recharge of the groundwater table. And that's why we design roof infiltration systems for all of these types of applications.
Okay. Anybody else? Okay. Good. Hearing nobody. You want to close the hearing?
Yes, please.
Okay. So at the request of the applicant, we will close this hearing with a vote. And voting on this will be the 5 members that are here. Okay. And this is for a special, well, we'll get to that special permit. Okay. All those in favor, first, does somebody want to make a motion to close the hearing?
So moved.
Moved by Judy.
Second.
Second by Drew. Any further discussion on closing the hearing, please say aye.
Aye.
Opposed? Abstain? So carried. Okay. So now, are there some conditions people would want to put on this special permit?
Mr. Chair, that's something I was thinking, if there was any potential way that we could try to make sure that any additional water impacts would be somehow monitored, and if it turns out that Mr. American is not correct and there was some additional water impact to the Barcelos, that there would be some follow-up. But I'm not sure how that would work.
Yeah, I think that's really difficult to do. In fact, that just actually goes to the point where, if we don't get it right, we don't have a chance to come back on something like this. If we grant permission for the garage and the underwater, the discharge underground, that's it.
The only condition I foresaw was that we received a letter on November 5th. I'd like to see that resolved before any building permits issued for that. Because right now, we don't have anything from the Board of Health saying that that's been resolved.
So, just on Drew's point, so that would, November 5th from Landis Hershey is the date of the letter
Right.
regarding the, I think it was a French drain system.
Yeah, I don't,
Yeah.
whatever it is. There's a couple letters here. I mean, the attorney studied it and told us it was 6 years ago, but it looks like it was a month ago.
Yep.
That's my feeling on a condition.
So you'd want a condition that says no building permit is issued until things get resolved with the Board of Health?
Yeah, I mean, this is from Landis, so.
Conservation, right?
Conservation. And it's a notice of non-compliance.
Right.
Correct.
Where do you stand on that?
It's been resolved.
That's been resolved?
Yep.
Okay.
So you can condition that, and we can document all of that.
We just don't have record of it.
Do you have a record that it's been resolved?
Well, the work that Landis Hershey requested has been completed, I believe, or it certainly was underway. It's been completed, so I don't know that Landis has been out to inspect it, but the work that she asked us to do to resolve that has been done. So we'll follow up with her. So if you know, as Mr. Delaney indicated, if you condition that, we can certainly document that through the the Conservation Agent's office and provide that to you.
Okay, so that would be one condition. Anybody have any other conditions?
I just had a question for the engineer. It looks like there's 26.4 feet rear yard setback on the garage. And does that have to do with the 30 minimum, and it's the garage height is less than 15 feet?
It's an accessory structure,
Yes.
so it's less than 22. It's 22 by 24 or smaller, or less than 15 feet high, so it has a reduced setback.
Okay. Thank you.
Mr. Chair, there's also comments from the town engineer. They were submitted the first time the board had met on this topic, but just a copy for the record, if you want to include those as conditions.
Comment from the town engineer, no technical comments or objections in granting relief. DPW engineering should observe, inspect infiltrator system and excavation and prior to backfill as built showing location should be furnished upon completion. So that would be another condition to add. Okay. Anything else? Lauren, you got those? Okay, so those two conditions. So does somebody want to make a motion to approve case number 24-19 to allow a special permit under section 12(3)(c)(5) to allow impervious coverage in excess of 15% within the Water Protection Overlay District in Area 4 for the two-car garage.
So moved.
Okay, moved by Judy,
Second?
second by Mark. Any further discussion on this? Okay. Okay. So on this, Tim, how do you vote?
Aye.
Okay, Judy,
Aye.
Drew,
No.
and I vote no.
Aye.
Okay, so 3-2 does not pass.
Thank you.
Okay,
Mr.
Next.
Chairman,
Yes.
it did not pass.
it did not pass.
Mr. Barcelo, it did not pass. I don't think you could hear us. Okay? It did not pass. Okay.
Okay, next case we have tonight is Pinnacle.
Oh,
Yeah, you need to step
I feel
down.
like a jack in the box tonight. Can we just sort of lump these together
Getting your
next
steps in.
time, please? I didn't wear my watch. All right, I can put that over there.
Okay, so, Mr. Petrosi, before we get going on this, it's up to you, but you'll notice that Board Member Dave Andrews is, Dave Anderson is not here tonight, so he's already missed one meeting. If you want to go forward with this, you'd be dealing with a 4-member board.
We didn't know until late.
You didn't know about this?
We didn't know about it until... At what time?
It's a late,
Yeah,
late
he's sick.
cancel.
Yeah.
So what's the rule? You can only mull in one
You
meeting?
can only mull in one.
Oh, jeez. So we don't have to open the hearing, we can open it and continue it?
Yeah.
Is that what you're saying?
It's up to you. It's, as you know,
Oh,
it's
come
your
on.
hearing.
I always like to have 5. I like to have 5 people, you know, I like to have 5. 1, 2, 3.
And
Oh, Drew's here, right?
Cruz just stepped up. That's why we haven't opened the hearing yet.
Okay.
We haven't taken any evidence. So it's up to you how you'd want to go forward.
So we shouldn't open the hearing then, basically?
Yeah, we would just we just continue it without any testimony. Or you can go ahead with a four-member board.
Yeah. What is your meeting schedule going forward?
January 6th?
So I won't be here for that.
Okay.
Working.
So January 8th would be the next meeting, and John's not available for that meeting, so it'd still be.
But you could do Mullen then.
You missed one?
Did I already miss one on this?
No, only Dave and Drew have
So-
missed.
Do we have a meeting scheduled for like January yet, or do we know what the
Well, we're
deal is?
actually voting on that tonight.
Patrick suggested we line it up with your,
Dupee?
With the Pinnacle 40B,
line it up with the Pinnacle 40B
February.
in February.
It's up, I mean, it's up to you. It really, if it's January 8th, you'll still have four members.
I think we're at the tail end of this
Yeah.
process. Why should we piggyback on the 40B? but-
I don't disagree, I actually agree with you on this, Mr. Petrosi. We're pretty, I think this is a 40A application.
Right.
I think we're at the tail end of it.
Right.
And really what it comes down to is, what are the neighbors saying? If approved, you'd still have to go through other.
Oh, yeah, no,
permitting.
that's we're kind of anxious to get to that point and proceed with the other. So do you have meetings in January besides January 6th, or is it January 6th or 8th?
8.
8th is Wednesday. I'm busy on the 8th anyways.
So the backup date, if the board votes on it, would be the 27th.
Okay, but-
And that's due to the holiday, and I think that's the fourth Monday, because there's a holiday previously.
Yeah, it's Martin Luther King.
It'd be the 27th, which is the
Okay.
week previous, before.
You want to do that? Are you around on the 27th?
I will be back then, yeah.
Well, I'm perfectly happy to take another 6-week vacation.
Enjoy the holidays.
Okay. So,
I guess that's what we should do because,
do you want to continue it until the did you say January 27th?
Let's January 27th or February 5th, if he wants to keep it.
27th. I don't want to mix the other 40B up with this.
Okay.
I would still, I think we need an extension for that.
We would still need an extension of time for the public hearing. So you're at the end of it. Yeah, this one expires, I
Well-
believe, the end of
Like right
December.
around-
Well, actually, the time doesn't expire until the
It's,
close of the hearing. So you have 65 days from the close of the hearing to make a decision. There's no timeline
Is this
for the
one?
application, in other words, for a special permit.
I mean, the 90 days.
But I'll give you one,
Yeah.
whatever you want. I
Yeah,
don't think
we
you
would need
need
it.
it, but
All right.
I would do it through February.
Yeah. Or through the end of January at the very least.
maybe that time we'll have Dupee Street ready too. You never know. Or February 5th we can do. I don't want to pile everything on one meeting.
Well,
So Patrick, continue, I'm just writing this down.
yeah.
Continue until January 27th with an extension of time until February 1st.
But,
Yeah, I mean, that,
yeah, I don't mind, but I don't think you need an extension with a special permit, but,
You might be right.
well,
February
usually
1st is Saturday.
pretty good at this.
it wouldn't matter. It just, we'd have to deal with that on
Then-
the 27th. The board doesn't make a decision.
Then we can do Pinnacle 40B and Dupee Street maybe that day, on the 5th,
Yeah.
okay? That way we're freeing up some time.
So we would continue this until January 27th with an extension of time until February 3rd.
That's the Monday.
That's the Monday.
Okay.
Is that okay with you, Mr. Petrosi?
Yes, yes. We haven't received any other comments, so I don't know what other information is going to be put into the record other than,
So we're going to not take any testimony on this case tonight, but at the request of the applicant, we would continue this until January 27th with an extension of time until February 3rd. Does somebody want to make that motion?
Is that both 2411 and 2413?
Yes.
Okay.
Yeah, they're both part of the
Yep.
40A
Yep.
application. Both, yes. Thank you for clarifying that.
So moved.
Okay, moved by Drew,
Second?
second by Tim. Any further discussion on this?
That's a Monday.
What's that?
And that's a Monday, 27th, just a...
The 20, I thought you said, what day is that?
Yeah, I'm just saying it's a Monday.
Fourth Monday.
Okay, it's a Monday, I can do that. And extension of time until February 3rd. Okay. All those in favor, please say aye.
Aye.
Aye. Opposed, abstained, so carried. Okay. Okay.
Go home early tonight.
Next, we have some minutes from previous meetings.
Have a good holiday.
Thank you, you too.
You too.
Okay, so we have the, I'll take them in order, minutes of November 6th, and one of the things, I looked at that cleared up the 300 Stone Street. Everything else looked good on that. Does anybody have any edits or comments on that?
On the 6th?
Does somebody want to make a motion to accept the minutes of November 6th?
So moved.
Moved by Drew, second by Judy. Any further discussion on the minutes? All those in favor, please say aye.
Aye.
Opposed? And I think everybody here was there for that. Okay. Next, we have the minutes from, seems like, was that our last meeting, the 18th? November 18th. This is the last time we met, and most of them were, we had the continuation of the case that we just had. Somebody want to make a did people have a chance to review these? I did.
Skimmed them. Didn't see anything.
Okay. Somebody want to make a motion to approve the minutes of November 18th?
So moved.
Moved by Drew,
Second?
second by Mark. Any further discussion on those minutes? All those in favor, please say aye.
Aye.
Opposed, abstained,
I'll abstain.
okay. Okay.
March 17th is the second meeting in March.
Oh, should we not do that one?
It'll be a raucous.
What-
The second meeting in March is St. Patrick's Day.
Yeah. Not your preferred.
Just try to meet once in March then, I guess.
July too might be lightly attended, being so close to the 4th.
That's a good one.
Yeah.
Yeah. We want to,
We could maybe push
Well,
back to the.
one of the things we try to do in the summer is really
One.
one meeting.
We
but-
could always drop that and just do the 21st. If you want.
as the primary meeting date.
I think my vote would be for that, without having any clear
Yeah.
conflicts at this
Yeah.
point.
You want me to remove the March 17th as a backup date?
I think that's best to remove that one.
Where are you going?
Oh, I didn't say, I'm okay with whatever you decide.
Got to keep his plans open. You know?
I don't have Fitzpatrick, just so you know.
Oh, no. I only have a
Just,
little.
I'm just looking at the October.
That's good.
Yep, October looks okay.
August, just leave it 6th.
So striking March 17th and July 2nd. Is everybody else feel comfortable with those dates? And I think we're trying to do a good job, having meetings when we need them, but not having too many meetings, so. Okay. So you got those two changes? Anything else? Somebody want to make a motion to adjourn?
So moved.
Moved by Judy.
Second?
Second by Tim, just in time.
Snuck in.
All those in favor, please say aye.
Aye.
Opposed, abstained. Good night, everybody.
Merry Christmas.